Okay. And then Ms. Lawrence is with us as well. So Ms. Baldwin, let me turn to you.
Thank you. So this is on for review regarding child support payments. We were before the court back in on December 9th regarding a contempt action. The court set this out to February to review to ensure payments are being made. Where we are now is payments are not being made in conformity with what the court ordered. So the court ordered that she had to make essentially the base payment and then $75 towards the arrears beginning in December. We did file the case payment history that shows no payment was made for December, and $569 was paid in January. So if you, what the court ordered would have been $873 in regular child support payments over those 2 months and $150 in payments towards arrears. So that'd be a total of $1,023. She's paid $569. She's just not in compliance. So again, this sort of fits the pattern of I'll do what I want, when I want, how I want. So just paying essentially what she wants to. That's not what the court ordered. We're looking for her to be in compliance and to face attorney fees and a sanction for today.
Alright guys, let's break this down. The case opens with the attorney laying it out bluntly. Court orders were clear, payments were not. The numbers don't lie, and the gap is already glaring. What really stands out is the pattern accusation. This isn't framed as a mistake, but a habit of selective compliance. Right out the gate, the tone is set. This isn't confusion, it's control versus accountability.
Ms. Fairchild, and I did, Ms. Baldwin, receive the cover sheet of the payment history, looks like at least through February 3rd. Ms. Tiffany, what would you, or excuse me, Ms. Fairchild, I knew I was going to do that. What would you like?
Well, I did actually make a payment at the end of December, which was then processed at the beginning of January, and I made a payment in January. So I'm not sure why the child support payments are not being accredited. I did do them through my online bill pay through my bank. And I will be making the February payment this next coming week. So that should be credited in the month as well. I'm not sure why it's not on there, but
do you have some, and I'll let either party tell me this. The ledger that I had has the last payment being receipted in as January 9th. Has there been a payment since then?
Miss Fairchild steps in with a classic defense. Payments were made. The system just didn't catch up. She shifts the blame toward processing delays and banking timelines, trying to reframe the issue as technical rather than intentional. It's a strategic move, but it also opens the door to scrutiny, because in court, "I sent it" doesn't carry weight unless it's officially recorded.
There was two individual payments that were deducted from my bank account in January. One was the December and one was the January.
Yeah, I have January 6th and January 9th. A total payment of $494.
Of $494?
Mm-hmm.
There should be two payments of that amount for that total amount.
That's what I'm saying. Each payment. So the one that's receipted in January.
I'm sorry. So each payment is $494?
Correct.
Well, yes and no.
Yes. If each payment is, it's when child support received it and documented it, but one is the December payment, the other payment is the January payment. I unfortunately do not have any control over when child support receives that payment and then credits it.
I'm just trying, Ms. Baldwin, I'll turn to you. I'm just looking at the payment ledger that has those two entries, 1/6 and 1/9. And it says the total payment on each of those dates was $494.
Yes, okay. which is the base amount plus $75 additional.
All right. Hold on, Ms. Fairchild. Ms. Baldwin, go ahead.
Thank you. So even if she paid $494 in December and in
Now the conversation dives into the weeds, dates, amounts, ledger entries, and suddenly clarity disappears. Both sides are technically right in pieces, but collectively it's a mess. This is where many cases get stuck, not in outright defiance, but in murky documentation. Still, the court isn't here to decode confusion forever. Someone's version is about to give way.
January, the base, that would have been the base payment for December, but that is not the base payment, the $75 for January. So the child support order changes. So essentially the court had ordered a reduction up through the end of 2025. And so her payments were actually less. Beginning in 2026, her payments are a little bit more. So her payments went from base payment from $419 to $454. And so the $454 plus $75 would be $529. So again, not meeting the base obligation that the court, even taking her at full value, not meeting that base obligation that the court has set.
Here's the turning point. The attorney drops the key detail. The payment amount increased in January, and that changes everything. This isn't just about missing money anymore. It's about paying the wrong amount entirely. Suddenly, even if payments were made, they may still fall short. The narrative shifts from did she pay to did she pay correctly?
Ms. Fairchild, were you aware that it had increased from $419 to $454?
I was not aware of this increase, and so I do not know. I was not aware of this increase. I paid the amount for which I was ordered, which was by the court, which was $419 plus $75. I've made that payment for December. I've made that payment for January. If there was an increase that I have not been aware or made notify of, I have no control over that. If there's simply an increase of less than even $50 for that change, which means that in 1 month there's only a $50 change that was made, less than that, I do not believe that is reasons for any kind of penalties or contempt when there's many times that paperwork has to get processed and received, and then you've got to make changes to your online bill pay in order to have that changed.
Ms. Fairchild pivots fast, claiming she had no idea about the increase. It's a reasonable defense on the surface, but it also raises a bigger issue: responsibility. Court orders don't adjust themselves quietly. Her argument leans on lack of awareness, but the court typically expects proactive understanding. The tone here feels less confident, more reactive.
How, Ms. Baldwin, help me out. How was that change made, or where was that change made? I'm just looking at the $419 amount.
Yeah, so the court, if you look at the order in contempt, it does not say she pays like $495 or whatever she's claiming. It says pay your base amount, pay $75 towards arrears. If you look at the order of child support from August 18, 2025, that's where the change is. So that order very specifically says, page 3 of that order, hey, it's $419 through December 31st, 2025, beginning January of 2026, it's $454 is the base amount. So that
I was unaware of this, Your Honor. I'm sorry, I was unaware of this, Your Honor. I thought I was making the payments correctly. For the February payment, I can add in the additional that was due for January. I was unaware of that change.
When are you making the February payment?
I'll make it by probably midweek next week so that it can still apply to the February ledger.
The attorney reinforces the timeline with precision. The increase was clearly written into a prior order. That undercuts the "I didn't know" defense significantly. Meanwhile, the judge acknowledges a system mismatch, which complicates things but doesn't erase responsibility. This moment tightens the pressure. The margin for excuses is shrinking fast.
So the ledger that was printed out for me, 2-3, so Ms. Baldwin is correct in the August 2025 temporary child support order. It does have that increase effective in January. The ledger from the state of Washington still lists the amount due as $419, so they will need to update that as well. But what I'm going to do, Ms. Fairchild, is set a review date for your February payment. What I need to see is that, contact the state, whoever, if you have a support enforcement officer that you're talking to make sure that they're aware of that increased amount, Now that you're aware of it, it is $454 as of January. So I want to see that you've made up that difference for your January payment. And I want to see that your February payment is correct, that it's $454 plus the $75.
Yes, Your Honor.
And you said you think you're going to make that next week?
I'm hoping to make it by midweek next week.
I mean, that's putting us up against the end of the month, and I'm concerned about it being receipted. It needs to be.
That's also an additional amount for.
Ma'am, here's the deal.
February, so I'm going to try to get that together.
Okay, well, I'm giving you a little bit of the benefit of the doubt right now.
Now the judge steps in decisively. There's a brief window of grace, but it comes with strict conditions. Fix January. Pay February correctly. Make sure everything is officially recorded. This isn't a suggestion. It's a line in the sand. The tone is firm but fair, signaling that patience exists, but it's running out quickly. Start at 8:14, end at 9:02. The focus shifts to timing, and this is where many people slip. The judge makes it crystal clear. It's not about when you send the payment, it's about when it's processed. That distinction is everything. Waiting until the last minute won't cut it. The system's clock, not her intent, will determine compliance.
So it must be what I have just requested. The difference in January and the full February payment has to be receipted in so that I can review it. Okay.
Yes, Your Honor.
It must be receipted in by February 27th, which is the last working day, last business day of February.
Okay, Your Honor.
Okay.
And if I just want to clarify, when you say it has to be receipted in, essentially it has to show in the case payment history.
Yep. And that means, ma'am, you can't pay it on Friday the 27th.
I understand.
Okay.
I understand.
So let's set this for a review for your January makeup payment and your full February payment.
A review hearing is locked in, and with it comes real consequences. The judge holds off on penalties for now, but makes it clear they're still very much on the table. This is essentially a probation period. On what happens next will decide whether this becomes a compliance story or a sanction story.
What date would work for the parties?
I'm going to do March, just that Friday, first Friday of March, March 6th. It's available for everyone.
Yeah, could you do March 6th at
Yes, Your Honor.
8:45 via Zoom?
Yes, Your Honor.
Okay. We'll set you to my presentation docket for that. Ms. Baldwin, was there anything else you wanted to address today?
No, I think that's it. And then we can just address any further issues on the 6th.
Yeah, I'll reserve on any requests for penalties, sanctions, attorney fees, depending on what happens between now and February 27th.
And then while we're here, would Ms. Fairchild, would she spell her last name? And then if it's been changed in Odyssey, then I can just make sure our pleadings conform with that.
Fairchild, Fairchild.
Okay, and the only capital letter is the F?
That is correct.
Okay, got it. Thank you.
Yeah, and it is changed in our system now as well.
Okay, very good.
Okay. All right. Thank you both.
Thank you.
The hearing wraps with routine formalities, but the underlying tension doesn't disappear. Everything now hinges on follow through. The court has given clear instructions, clear deadlines, and zero ambiguity. At this point, it's simple: comply or face the fallout. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.